Before we jump to the Occupational Health and Safety Act, and I guess a second apology is in order, this is focused on occupational health and safety for those of you that are provincially regulated in employment and occupational health and safety matters. If there are any of you that are federally regulated, there are like types of provisions, but as you would expect, there are some fairly significant differences. On all of the subjects that I'm talking about, we have papers, memos, and the like that can deal with it in greater detail. You just need to let me know and we can send them to you, okay? But let's talk just quickly about the criminal code. It's important to remember that under the criminal code, there is scope for prosecution of persons and corporations for breach of health and safety obligations. Typically, under the criminal code, they are criminal negligence charges, either criminal negligence, just plain criminal negligence, or criminal negligence causing bodily harm, or in some cases, death. It was some time ago that the criminal code was amended as a result of the West Ray mine disaster, so that it's much easier now to prosecute a corporation than it used to be, and it can be predicated on the cumulative aggregate acts of various people who work for the corporation. So you want to be mindful of that. And then secondly, there's now a specific duty provision in the criminal code that imposes a duty upon those who are responsible for training somebody to do it in an appropriate way. So if you've got authority to direct how another person does the work or performs a task, you have to exercise reasonable care to prevent bodily harm to that person or to anybody else. And that aligns, it's different language obviously, but it aligns with essentially the same obligations under the Occupational Health and Safety Act. Having said all of that, it's much easier to prosecute successfully a corporation under the Occupational Health and Safety Act than it is under the criminal code, for reasons we'll get into, but it's still there. And you'll all recall the Metron case, that's the scaffold collapse case on Christmas Eve. 6 people are on a scaffold that's designed for 2 people. 4 of them died, one's critically injured, it's paraplegic, and one person was using fall arrest equipment, and he was fine. The litany of problems, it was appalling, not only with respect to the scaffold itself, but to the work practices. And in the result, and of course, 3 of the 4 deceased had drugs in their system. So, as I say, a litany of problems. Having said that, I pointed out to you because the corporation, there was a conviction and a fine of a director for $90,000, and it's essentially a 1 or 2 man company. In a criminal prosecution, the trial judge had given a fine of $200,000, and the Court of Appeal raised it to $750,000. And the supervisor was convicted of 4 counts of criminal negligence causing death, 1 count of criminal negligence causing bodily harm, and he got 3.5 years in prison. So it's not a provincial detention center, it's Kingston. And by Canadian standards, that's a fairly long prison term. And I did want to talk to you about Detour Gold. It's more recent. It's a case where a worker had only been with the company for about 3 months, and he's given a task to do, and he dies within hours from exposure to arsenic. Arsenic is used in the gold mining process. And this happened in June of 2015. Detour, initially they prosecuted Detour criminally, and they prosecuted the 3 supervisors criminally. Detour did a deal, what we call a plea bargain. Detour was fined $1.4 million. At the time, Detour had never made any money. It's a mine in Cochrane, but they were losing money, great prospects. And they were fined $1.4 million, victim impact surcharge, and there was restitution to the family of $805,000. So in total, it's over $2 million. The Crown withdrew the charges against the supervisors, the criminal charges, but they were charged under the Occupational Health and Safety Act. And there's any number of reasons why you don't want to ever be prosecuted, but Detour illustrates this because, as I say, it happened in June of 2015. The coroner's inquest starts next month. So it's Detour itself pleads guilty, but the charges against the supervisors under the OSHA have been in the courts for some time. It went to the Court of Appeal, and the supervisors had argued that it took too long to get to trial, that they wanted the charges stayed under the charter, because you're entitled to a speedy trial. And the Court of Appeal said no. So it was headed, and then at that point, after the time that had been spent on it, the Crown just withdrew the charges. But as I say, they'll all be there for the coroner's inquest. And if you are a supervisor, you should be mindful of the fact that that your employer has no obligation to pay your legal fees or your fine or anything else. So on that cheery note, we can move now to the Occupational Health and Safety Act. So it's the primary statute that governs workplace safety in Ontario. It's based on the internal responsibility system. It arose, you'll see when you read it and you look at it, it reflects a world that really isn't aligning with how our economy works at the moment, because it was drafted in the mid-70s. It was enacted in 1977, and people have been bolting on amendments and this and that and the other thing. So parts of it make no sense. Some sections are contrary to the charter, but it is what it is. And you have to always bear in mind that with public welfare legislation, be it the Occupational Health and Safety Act or the Human Rights Code, that it's given a liberal interpretation so as to achieve the objects of the statute, unless that would produce an absurd result. And there have been two cases recently, relatively recently, dealing with, well, what's absurd? So, as you know, in a workplace, the employer has to allow the union to the JHSC to inspect the workplace once a month. And this is a federal case, but the union then argued that that gave them the obligation and the right to inspect all of the routes taken by postal workers in Hamilton and every place that they delivered the mail to. So it would have created thousands and thousands of jobs for people just to drive around Hamilton every day. And it got to the Supreme Court of Canada because there were people along, tribunal officers and then judges along the way who thought, well, that's reasonable, and it's obviously patently absurd. But when it got to the Supreme Court of Canada, they said it's patently absurd. But it got to the Supreme Court of Canada, so not everybody agreed. So you have to be mindful that the absurdity issue's there, but it's not lightly used. So this is from the perspective, because we're informed about obligations by virtue of the prosecutions, because that's where judges hand down their decisions, right? So just so you follow what I'm trying to say about the basics. In a criminal code offense, the Crown has to prove beyond a reasonable doubt both the prohibited act or omission, and equally the intent to have committed the prohibited act or made the omission. In a strict liability offense, almost all OSHA cases are strict liability offenses. The Crown only has to prove the factual elements. They only have to prove the prohibited conduct be it an act or an omission, they have to prove that beyond a reasonable doubt, but they don't have to prove anything at all with respect to intent. They don't have to negatively prove it, etc. So if they do that, they get a conviction. Unless the accused, or as in regulatory offenses, the defendant, they call it, establishes due diligence. So the Act defines workplace parties, imposes obligations upon those workplace parties, and those obligations are in the Act itself, or they're in the regulations to the Act. And there are 25 regulations. There are sector-specific regulations. So there's one for construction, there's one for healthcare, there's one for industrial establishments, there's a couple others, but those are the three ones that we most encounter. There are sectors of the economy for which there's no sector-specific regulation. They're still governed by the Act, and they're still governed by the subject-specific regulations, but they may not have that. Of the subject-specific regulations, the two that I wanted to point out to you because of their importance is the Occupational Health and Safety Awareness Training Regulation, okay? It was brought about as a result of the Metron case. It imposes obligations to provide training to your staff, and a lot of employers aren't doing it, haven't done it, and it's a breach of the Act to not do it. So you want to be mindful that you're aware of that regulation and the time constraints. It's divisible into parts. I don't get into the parts today about it, but it's not, look, if this was rocket science, I wouldn't be the guy doing it. So you just have to read the regulation and be mindful of the obligations. And part of it deals with just all of your workers, and part of it is additional awareness training for your supervisors. And we're going to talk about supervisors in a few minutes, but I wanted to draw that to your attention. Secondly, a year and 4 months ago, they amended the law, if you will. So the old confined space as well as the old critical injury regulation is gone, and now there's this new regulation in place, and it deals with what reports and what notices have to be given when you have workplace incidents like a fatality, a critical injury, an occupational illness claim, etc. And it's drafted by lawyers, so it's a bit, if you want to know how it all works, just send me an email, we'll send you the damn thing. I think it takes us 9 pages to explain something that's 3 or 4 pages because of the way it's drafted. But you have to be compliant with it. We continue to have issues with, the clients are continuing to have issues of not getting the notices and the reports out the door within the requisite time periods, okay? And the fact that you might have a great reputation with the Ministry of Labor isn't going to save you. People get prosecuted. We have had cases where churches have been prosecuted for not doing it, hospitals, children's aid societies, so be mindful of it. I mean, they're not always going to prosecute, but in some cases they do. They will prosecute if they think that you didn't make the report because you wanted to avoid them finding out about some problem in your workplace. So, as I said, it defines workplace parties. The takeaway here is that the definitions in the Act of workplace parties aren't going to be the same as the definitions in the Employment Standards Act or in the Labor Relations Act or the Canada Labor Code. So only in a world of lawyers do you have different definitions for the same damn word from one statute to another, but it is what it is, okay? You can't contract out of the Occupational Health and Safety Act, save for one exception, which we're going to talk about briefly. So, you just can't. Those are your obligations. So you can't contract out of that anymore. You can contract out of the Human Rights Code. So you got to be mindful of who you are in this scheme. The same entity can be at the same time an owner, a constructor, an employer. So you need to know that. And you need to know who are your supervisors. And many people, this is one of the problems we're coming back to, okay? So an owner, like you'll see the definition here. I put it up because for OSHA purposes, it includes a tenant. Well, there's no other statute that would say that a tenant is the owner of the building, right? But for OSHA purposes, you are, and an agent is an owner. So when it talks about owner obligations, turn your mind to that because it may be you. Employer is the big one. When they drafted the act, the mischief that they were aiming at is the number of employers who at that time, under the prior legislation, and there was 3 statutes then, 3 separate ones, but they got out of their safety obligations by just hiring independent contractors, and they could wash their hands of it. So it has this broad definition. It includes contracts for anybody who employs one or more workers under contracts for the services of one or more workers. And it's incredibly frustrating because there's a difference in law between a contract for services and a contract of services. Now, most lawyers don't know that. Why would you? But they are different. And what I'm about to say, just a quick illustration of it, okay? So it includes dependent contractors that you have. It includes independent contractors that you had if they're providing services to you. And it can include the employees of third-party companies that you've contracted with for them to provide services. So, you have obligations. And these cases, Wyson, the guy's a window cleaner, but he doesn't do high-rise buildings. He gets a contract for a high-rise building. He subs it out to a guy he knows who does the high-rise stuff. That guy dies. They prosecute Wyson successfully. Grant is a forest products company up north. They make lumber, and they use a temp agency from time to time for extra staff. One of the temp agency's employees in the employment law sense gets injured. They prosecute Grant successfully. Pioneer, the Ministry of Transportation hires Pioneer, which is a construction company up north. Pioneer hires a company called Brooks, which has trucks. Brooks hires an employee to drive its trucks. At the Pioneer site, the employee's in an accident and he loses his legs. They prosecute Pioneer. They don't prosecute the trucking company. They could have. They could have also prosecuted the Crown, the Ministry of Transportation, but they didn't because that's their choice. They have that discretion. Just to be clear, the Crown prosecutes the Crown, right? So we have cases where the Ministry of Labor has prosecuted other ministries, other agencies. There's a process they have to go through in order to do it, but everybody's subject to it. Constructor. This is a continuing problem. I rather suspect that most people in this room aren't engaged in construction or think they're not engaged in construction. And I wanted to raise this issue with you because it's a continuing problem. An owner who undertakes a project, remember my broad definition of owner, so if you're a tenant, if you undertake a project, then you may be the constructor, and so we want to just remind you of this. So a project, and I recognize this is profoundly boring, but it is what it is. So there's the definition of project in the Act, right? And it includes all these objects, a building, a bridge, a telegraph, whatever. And it has in it the word construction. So if the object is in that definition of project, it's a building, it's a highway, then that's the first part of the test. If your object that you're talking about isn't in there, then you don't have to worry about the construction project. But if the object is, and for most of you, it'll be your building that you're in, right? Then you go to the next, which is construction. And these are the various activities. And it's everything you can think of doing for construction, except that, and this is why it's problematic, you'll see it says structural maintenance. So in the result, regular maintenance isn't construction. So if you have a building and you have your workers there, and you're just bringing people in to do routine maintenance, that's not construction. So you're governed by whatever sector-specific regulation governs you, if there is one that governs you. But typically it's industrial, right? Like, I don't know how many floors we have at Miller Thomson, I don't know, 3 or 4 or something. We're governed by the industrial establishments regulation. It seems a bit odd, but we are, okay? And many of you will be. Unless what you're doing falls within this definition. And the position of the Ministry of Labor is that if you read the definitions carefully, okay, maintenance is not construction, but the installation of equipment and machinery is. And many, many clients fall into this trap. Oh, we're governed by the industrial regulation. You know, we've hired ABC to come in and install, a MRI machine or something. Well, that's construction, okay? And if it's construction, that construction regulation applies, and it has much more onerous obligation than does the industrial establishment regulation. And somebody's got to be the constructor. On any construction project, there has to be a constructor. And my takeaway from this for you is you don't want to inadvertently become the constructor. If you turn your mind to it and decide you want to be the constructor, that's great, because there's people there that can help you understand what your obligations are. But you don't want to find out after somebody's been hurt that you were the constructor and you didn't follow any of your obligations as a constructor. I already said this. And this is the quote from the Ministry of Labor, right? Distinguishing between the two of them, but even they've got it slightly wrong here, but it is what it is. So just really please be mindful of that, because you know, if you're doing construction and you shouldn't be doing construction, or you're not aware of it, not only are you in breach, but you run the risk that they're going to shut down your operation until such time as your ducks are in a row, as they say. This is the test that I spoke of. Because it doesn't matter what you say in your contract documents, if in practice you're carrying on as if you're the constructor, then you're going to be the constructor. And this happens, there's some cases here. We won't focus on the ones that we hear that I lost, but in A&P, they were clearly running the project. They're deciding, even though somebody's named to be the constructor that isn't A&P, they were clearly organizing the trades, approving the work, directing the work, all of that stuff. They were the constructor. Same thing happened in General Motors. They were trying to be unduly cute, right? Because they really did want to run the projects. In Home Depot, we won, but because they knew where they were on the line. They're really well organized, but they didn't cross the line. In Sudbury, It's a contractor that's doing construction work in the city. A guy operating a backhoe hits a pedestrian and kills him. And Sudbury gets prosecuted, I think it's 5 years ago now, and went to the Supreme Court of Canada last week. So it takes time, and it can be really, really expensive. Praise the Lord. And there are suppliers. There's obligations imposed upon suppliers. So if you're drafting contracts and you say, okay, well, we'll include in the contract price, we'll let you use our backhoe or our equipment. You want to be careful how you word it, because you will have just now also become a supplier, and that imposes supplier obligations on you. So again, we have, and I'm not from the marketing department, I can't spell marketing, but we have, handouts that we can give to you if you're interested in any of this, okay? Supervisors. A supervisor is a person who has charge of a workplace or authority over a worker. It's disjunctive. He doesn't have to have both. It's one or the other. And it's objective. It doesn't matter that the person isn't called a supervisor. The Act doesn't talk about managers. It never uses the word managers. If it's a person who does either one of these two things, it's going to be a supervisor. And it's imperative that you identify who they are, because there's all kinds of obligations upon you as an employer or a constructor to do things to make sure that your supervisors are trained and competent. There used to be this checklist. Fire a worker, ability to exercise discipline, decide who's on your crew, the equipment. Well, that's not the law anymore, okay? If you look at this, I have no ability to fire anybody. That's Heather's job. I don't discipline anybody. I don't decide who works for me. We certainly don't tell anybody what equipment they have or what kind of computer they have. And I have 5 minutes to go, so I'm going to be very quick. We won't. It's control. I mean, if the person's looking to you for how to do their job, they're the supervisor, okay? And they need to know they're the supervisor. And you need to know, because as I say, you have obligations. It can be anybody in that continuum, right? That's not the lead hand, and it's not just the chief executive officer. Anybody on that hierarchy. There has to be a nexus, right? So the fact that somebody's a supervisor in our Vancouver office doesn't make them a supervisor of my assistant in Toronto, right? Anybody, okay. Duties. So the Act imposes these duties on workplace parties. So once you've identified who you are you the owner, are you a supervisor, are you a constructor, employer, whatever, then you need to be mindful of the duties. The duties are in the Act and in the regulations, okay? There's all kinds of them. And I just highlighted on the slides, and there's a memo if anybody wants it. It's I think it's 35 pages, but it talks about this stuff, so you can have that if you'd like it. And if you are asking, not that anybody will, but if you do, you might want to identify what's the nature of your business, so we don't send the construction to somebody who's running a children's aid society necessarily, right? Look, if you're supplying, you have to know what the Act says about the employee. Look, you don't need to get into the minutia of, how some of these things work, unless it's absolutely germane to what you do at work, right? But yet, the law is predicated on the assumption that there's a social license. You've decided to be in that business. You're in the best position to know what the hazards are of your business, and you're in the best position to know what is the way to deal with them. The one, I'll skip over them, but they're here in the slides and in any papers we give to you. I said earlier, due diligence. So you need to know who you are, you need to know what those duties are, and you need to have a regime in place to make sure you're compliant with it. And it requires that there be policies, that there be programs to implement the policy. The programs have the measures and procedures that you're going to use to do that, and that has to be part of training, both at orientation and at recurrent intervals thereafter. One of our clients quite wisely has a system, a regime that we designed for them and with them, and they do their recurrent training in the month of everybody's birth. So if you're born in January, everybody in January gets the recurrent training in January, even if they just joined you in December, because that way they spread it out over the year and it doesn't fall through the cracks. And you have to discipline people, right? I'm not saying everybody gets fired for cause, but in the absence of discipline, the ministry is going to argue you've got a culture of non-compliance. The other one I wanted to talk to you about just quickly is, and this is going to segue into what my friends are talking about, you have to take every precaution reasonable in the circumstances to protect your workers. That includes compliance with manufacturer standards, standards like CSA, ANSI, whatever's applicable to your work. I'm getting the yank, anyway, I just went on it, but I would urge you to, if you want, just send us, we can give you a paper about it, okay? And you've got to follow the new notices regulation, okay? Thank you.
Okay, thanks, Rob. And just to Rob's point, in terms of the materials here, we've got a lot of information, the slides, and we're not going to touch on everything, but they are going to be sent to you after the day's over, so you'll all have this for reference. So, for example, in my presentation come up, I have a lot of information about some of the case law. I'm not going to go into detail on it, but you'll have that for your reference. And when we do send the materials out, I don't believe they're including the 35-page memo Rob was talking about, but I'll let you contact him directly about that if you're looking for some extra reading material. I'm going to touch quickly on labor arbitrators and what they've said about COVID vaccination policies and the occupational health and safety obligation. I'll talk a bit about some WSIB policies about COVID-19, and then to move us on, we'll talk a little bit about mental health in the workplace in the form of a couple of the policies that WSIB has about mental stress. And I will touch on briefly the Morningstar case, which is about whether somebody can sue, for example, for constructive dismissal, where the constructive dismissal is based on workplace harassment that's occurred, and whether that's barred by the Workplace Safety and Insurance Act. So in terms of labor arbitrators, and this is really where most of the case laws come out so far on mandatory COVID vaccination policies. I know some of you in the room do have mandatory policies. Some of you may have taken them away or paused them, or maybe still thinking about them. So I think this is still going to be relevant, and arbitrators have really focused on that part of the Occupational Health and Safety Act that says you have to take every precaution reasonable. And a number of arbitrators have said that having one of these mandatory COVID vaccination policies in the circumstances of the given workplace is what you had to do as an employer under the Act. Now, that's not going to be something that's applicable for every workplace, but it is something that's going to be applicable in many, especially where you have frontline work, whether it's somebody performing healthcare services out in the community, in a hospital, delivering other care in homes, or your workplace, your manufacturing line is one where everybody just has to work side by side and you can't physical distance. So there are many different examples, and here I've included a passage from a case by arbitrator Stout, and he talks about the balance. You have this obligation under the Act, and that's sometimes going to trump an employee's right to privacy and bodily integrity, even though that's also fundamental. Another case that spoke about this is a Paragon case, which is a security company. And you can see there that the arbitrator relied heavily. He thought having this policy was taking every precaution reasonable. And this really is what arbitrators have focused on. They've looked at what are the circumstances, they've looked at what is the effectiveness of the vaccine. There's been even some recent commentary about, well, maybe the vaccine's not as effective as preventing transmission. But then we get to the thought process under the Act. Well, if I can still reduce the severity in my workplace of it, because I know people are going to have higher risk of exposure because of what we do, then maybe having people vaccinated is something that is a reasonable precaution, because I don't want them ending up in the hospital. So these are the considerations that come into play. As I said, we'll be sending this out to you, just a few other cases, but there are many more cases here where labor arbitrators in Ontario have touched on this. We're still really waiting for the courts to weigh in. There was a good case you may have heard about from BC a few weeks ago that said it's not constructive dismissal to put somebody on an unpaid leave because they refuse to get vaccinated under a mandatory policy. We're still waiting for something like that in Ontario, so stay tuned for that. Okay, turning to WSIB then. In terms of what the WSIB is saying, it's not a policy, but it's something they're including in their materials, and they think that because we're having all these restrictions lifted, you've got widespread community infection rates, etc., it's going to make it really hard going forward to prove that somebody with COVID in the workplace got it in the workplace, and therefore it's a workplace claim. And so they're going to have to be able to show that the risk of getting COVID in the workplace is greater than in the public at large, and I think that's going to be increasingly difficult to define, and that it also significantly contributed to the person's illness. And some of the WSIB examples are about those frontline healthcare workers. It doesn't mean that that's the only kind, but those are just the examples that they're referring to at this point. And of course, if you have an outbreak in the workplace, reporting obligations. You don't have to report it if the employee's not sure where they got it, and if you don't have any other known COVID cases in your workplace. At that point, the WSIB is saying there's very little link to the workplace, so your normal reporting obligations aren't triggered by this. It's just like somebody having the flu or some other sickness. Now, turning to the Worker Income Protection Benefit Program, and this is the one that ties in with the Employment Standards Act, infectious disease emergency leave, where people are entitled to up to 3 paid days. And that's where you as an employer are responsible to give them this. If they're sick because of COVID, they need the time off to go get vaccinated. As we all recall back in the days when everybody was clamoring for them, you need a day off to go stand in line to go get your vaccination. And I'll come back to the overlap with the existing entitlements. And so you can be reimbursed for a payment of up to $200 per day for up to 3 days. Nothing is going to be reimbursed if you already had paid sick days as part of your policy. This was really to create a new entitlement for those who didn't have that protection. And we may recall when that was happening about 18 months ago, just a clamoring for more worker protections so that they could get vaccinated or have their income protected if they got ill, had problems self-isolating, etc. So onus on the employer, you have to determine if they're eligible for the leave, and then of course pay them, and then seek reimbursement. If it turns out the WSIB turns it down, doesn't really have any way of getting a reimbursement if they say that, oh, you shouldn't have paid it out. So you might just be out of luck on that, unfortunately. And the paid infectious disease emergency leave is going to end in March of next year. WSIB also has a policy about immunization against the infectious disease, and this is triggered where you have a mandatory vaccination policy in place, and then the person suffers suffers an illness as a result of getting vaccinated. But it's not going to be the regular side effects like you have a bit of a fever or chills or pains, fatigue. It's going to be something that's more serious, and it's where there's really quite an adverse reaction that the employee experiences. So they get a right to the policy under that, to the benefits under that policy. And again, it's where you have a mandatory policy. So just thought I'd show you some data that the WSIB has gathered about claims, and you see that there are a lot of claims that have been approved by WSIB. We see the huge year in 2021, and even 2022 is pretty large because that's a year to date, or year to date a couple weeks ago. So that presumably is going to go up, although it'll be interesting to see if their rate of approving WSIB claims for COVID are going to go down because it's harder to establish that it's workplace related. On this slide, in terms of fatalities data, you see that all of a sudden in 2020 we have the COVID-19 fatalities show up, and especially in 2021 form a pretty large proportion of fatalities that were WSIB claims. So that just shows you the impact that was having on employees in the workplace along with general society. And then this last data slide is just talking about the percentage of claims that are approved by WSIB. And we see in those years from 2020 that all of a sudden the new kid in town is about 50% of WSIB claims that are approved, which is pretty significant. So also not surprising as an insurance company that they're saying it's going to be a bit harder for us to approve these going forward because they're forming such a big proportion of the benefits that are being paid out and their time management. So moving on to mental stress policies, and I'm not going to speak much about the post-traumatic stress policy, but we'll talk about chronic mental stress and the traumatic mental stress policies. But we see here that the post-traumatic stress disorder is a pretty big proportion, and then the next big proportion of the claims are the traumatic mental stress. And the chronic mental stress is a very small proportion, but just anecdotally, I think you're going to see more, at least, claims for it. Whether they're approved or not by WSIB remains to be seen. But I think what we've all seen, and probably what all of you have known for a long time, even pre-COVID, that mental health is a growing issue in the workplace, and people making claims, certainly exacerbated by COVID. And so I think we just need to be aware that, for those of you that are WSIB covered, that be ready for these claims increasing in the future, and those percentages going up probably in terms of what WSIB is allowing. So let's turn to the chronic mental stress policy. And applicable, of course, if it's something that arises out of in the course of employment, you're not going to be entitled to the benefit because of normal workplace management. Performance management, discipline because of your misconduct, termination, those aren't the normal things. People may still try to claim them. Just like if you're in a unionized workplace, people can grieve anything. Whether they're going to be successful is a different question. So in terms of when entitlement's going to arise, you're going to need a diagnosis that you have some mental stress injury, and that is caused by a substantial work-related stressor that occurred because of work. So there's going to have to be something identifiable that has occurred. And usually in terms of what's substantial, it's got to be something that's excessive in intensity or duration in comparison to what you normally have in the workplace in that position. Workplace harassment, that is generally going to be considered to be a substantial stressor. Not always, but I think generally you're going to be fighting an uphill battle if there's workplace harassment. The employee is going to be able to establish that claim in all likelihood, if it exists, of course, if they can prove that it occurs. And we're probably all familiar between the Human Rights Code and the Occupational Health and Safety Act on what workplace harassment is, but just have it up there. And it's that course of conduct that you should know or you knew was going to be unwelcome and includes things like bullying as well. Interpersonal conflicts are not going to be considered to be a stressor that triggers entitlement to benefits under the policy, so long as it's not workplace harassment or something that a reasonable person wouldn't perceive as egregious or abusive. So that's the objective test, right? The reasonable person that the law loves to talk about, right? But it's somebody else standing in the shoes looking at it and saying, no, that was a very subjective reaction you had to that, very subjective perception you had to it. And that's not going to trigger your entitlement. So even in jobs that have a high degree of routine stress, they may be able to get a claim established, and it's going to arise generally where there's responsibility over matters involving life and death, or you're working routinely in extremely dangerous situations. As I said, the normal management of an employee is generally not going to be a stressor. In terms of a diagnosis, it's going to have to be something for WSIB purposes that's out of that DSM. So if you can establish that it's a diagnosis under that, then that's going to help with your claim. So in terms of chronic mental stress, just one case that I'll talk about quickly here. And this is a police officer, so this is a routine, high-stress job. And what this police officer was doing was responsible for looking at fraud in the seniors victims unit. And the officer felt that the stroke that the officer had was a result of the overwhelming stress in the workplace. And ultimately, was diagnosed with adjustment disorder and depression and anxiety. And what the decision said was, yes, routine high degree of stress, but because of the circumstances here, dealing with a very vulnerable population, really heightened timelines for trying to get things resolved, and the officers feeling that I can't get justice for these people, and I can't do anything to protect them in the future from similar things happening. WSIAT, the Workplace Safety Insurance Appeals Tribunal, decided, yes, this claim is made out here. There's a causal link between what was happening in the workplace and the diagnosis. So there are a few other cases here that happened. This one involves somebody who had various disorders, and there was entitlement under chronic mental stress because the diagnosis was there, and the supervisor engaged in behavior that was beyond the pale. It was oppressive, it was very personal in nature, it was happening on the night shift where not many people are around, and that was found to be workplace harassment and a substantial stressor. And then in addition to that, there was also, once the worker was moved to a safer place, a co-worker engaged in behavior that caused further triggering, and that resulted in a valid claim under this chronic mental stress policy. Now, turning to traumatic stress, similar to chronic mental stress in that it's got to rise out of the workplace. Normal workplace management isn't going to trigger it. You are going to have to show that one or more traumatic events occurred. There has to be a clear and identifiable event, and it has to be objectively traumatic, not just subjective. And some examples are criminal acts or horrific accidents. Could be threats against a person or their family members or others that they come across in the workplace. And generally, a traumatic event is going to be something that's sudden and unexpected. So just a listing of some traumatic events. Witnessing the fatality or the horrific accident, being the object of death threats or physical violence. So many of these things that I know you have policies in place and practices and training to avoid these things, but these are the things that are going to maybe get an employee entitlement if they occur in the workplace. Also, the employee has to have been involved firsthand, whether that's observing it or perhaps hearing it. So, example being the 911 call operator, for example. So that's going to be the sort of thing, but it has to be a firsthand experience in some fashion. So an example of a claim here that was denied was somebody who thought that a coworker had inappropriately accessed medical file. There was an investigation and it was found to not be substantiated. Then about a year later, the employee couldn't find some materials and made a sarcastic comment to a coworker, and the supervisor then basically issued a bit of a reprimand for inappropriate behavior by the employee. So the clerk claimed that what happened was a traumatic mental stress because of the way the worker was treated in these two incidents, and the appeal was denied, the claim was denied, being a lack of evidence to establish the first claim, and then also the second claim was not something that falls within the traumatic policy and the meanings there. And that the supervisor was clearly engaged in the second incident in undergoing the employment function. In this other case that involves somebody with a bipolar disorder, what happened is that the tribunal ultimately found that there was no entitlement because yes, there was this diagnosis, but it pre-existed, and there was a lot of medical evidence to suggest that it was linked to other factors, not what had happened in the workplace, which was apparently abusive comments that were happening in the workplace from not co-workers or management, but members who used the parking lot that the person employed. And importantly, the tribunal also relied on, you never raised these issues at all to management, which isn't definitive because some employees may have many reasons for not raising this with management, but also nothing in the medical records showed that there were any linkages in the medical where the employee was complaining about this to her doctor. So in terms of the last item, then, and all these cases again will be in the materials for you to take a look at. On the Morningstar case, just briefly, constructive dismissal claim. As far as a recap, constructive dismissal claim, there had been workplace harassment. The appeals tribunal said no claim was possible because it was barred by the Workplace Safety Insurance Act, because you can't have a civil claim about something that's compensable under the WSIB regime, which is really good news, but the court overturns it and says, no, that was an unreasonable decision. These heads of damages that are separate, and it's not all linked back to the workplace injury. So that's what it was in a nutshell. And then that makes life really difficult because it seems like people can make claims now out of a workplace harassment. And so it's certainly more difficult to bar them in court. But are there any silver linings? Quickly, this Ottawa hospital case. I only raised it because it was close to Halloween, and the employee alleged that she had been attacked by a bat, like the animal, the flying mammal, bat, in the workplace. And the union was very upset about a bunch of things. And ultimately, what the arbitrator says was on a preliminary motion about jurisdiction, I can't deal with the damages that you're seeking because that's because you think the employer is at fault, and WSIB is a no-fault situation. So all I can do is order some declarations about a breach of Occupational Health and Safety Act and the collective agreement. But maybe that's also too close to the workplace harassment. And then last case where the Ontario court now has maybe said something a little bit different from Morningstar, or at least given us a silver lining, where there was a finding in the case that the witnesses and documentary evidence substantiated that there was an accident, not an intentional assault, but an accident in the workplace happened. And what the court says in this case, after reviewing whether a claim could be barred or not, was that this was not incidental to the workplace where the claims were being made. It wasn't about post-employment conduct of the employer that sometimes happens, like if they're alleging theft or something, but there was such a strong connection between the workplace injury and the claim that was happening that it was really a tort claim disguised as a workplace accident. So the court says, no, you can't proceed with this. A little bit contradictory, maybe, so it gives the lawyers the opportunity to say, can you bar the civil suit? Maybe. It depends. But at least we can say that, which is better than it was after Morningstar. So with that, I will turn it over to Brian.
Thanks, Andre, and thanks everybody for coming to this session. My specialty is environmental law, so you might wonder what's an environmental law doing speaking at a labor and employment conference. There's obviously a fair amount of overlap when it comes to environmental law and occupational health and safety, when it comes to hazardous materials, lead and asbestos in the workplace, the WMIS regulations, and so Rob and I especially have a fair amount of overlap when it comes to our practices in this area. And what I want to talk to you about, building on some of what Rob and Andre have said already, is what's to some people may be an emerging field, but it's well caught within what is already our existing laws, and that's the impact of climate change on workplace health and safety, and specifically what should employers do. There, again, keeping in mind Rob's earlier talk, employers, obviously owners, and maybe supervisors would fit there. But I'm focusing, for the sake of simplicity, on an employer and on the overall catch-all duty, which you've seen mentioned a couple of times already, which is the duty for an employer to take every precaution reasonable in the circumstances for the protection of the worker. And of course, volumes have been written on what the word reasonable means at the end of the day, and that is the essence of why this is problematic in a way, in terms of actually implementing this duty. Again, Rob talked a little bit about this already in terms of the sort of the spectrum of liability that we have in this field, going from criminal proof all the way down to what we call regulatory offenses, which is the nuts and bolts of occupational health and safety, which is the defense of reasonable care at the end of the day, which once the event in question is proven to have taken place, a defendant can show evidence, positive evidence, that they exercised reasonable care to prevent the particular event. So again, there's that word reasonable, and you're sitting there in your job saying, well, what would reasonable be? And unfortunately, you'd only know you got it right if a judge says you got it right in the end, because we can't give you a complete, comprehensive list of what it is. Essentially, what it takes to be reasonable, to exercise reasonable care, is not defined. There's no fixed shopping list. It is everything that you can think of, but the key step is to basically recognize a hazard and do something about it. So complying with the law, that's your baseline. You're going to get prosecuted for one of those breaches, for any type of workplace accident, if it's thought you should have done something more about it. So right from the top, from corporate statements to following what the rest of the industry is doing, to attending seminars like this, believe it or not, to keeping proper documentation. But the concept is one of always continuous improvement, learning from near misses, learning from what's happening around you, and adapting. And the key to all of this is what's foreseeable. And if there is something foreseeable, then you should do something about it. What you do is the essence of how you show reasonableness in the end. And climate change is one of those things that is foreseeable at this point, clearly. And if climate change impacts your workplace, you need to do something about it. And at the very end, doing nothing is clearly not going to be reasonable. What you do is going to depend, obviously, on your own unique circumstances. But what I want to talk about is, well, what are these foreseeable impacts of climate change on the workplace? There are papers being written about this, and there have been, and the World Health Organization has done some studies and some modeling on this. And this is the list, from the obvious increased ambient air temperature to maybe some unusual ones like vector-borne diseases and allergens as well. And I'll go through some of this list with you. As we said, you will get some of these slides in the end. The really obvious one is the increase in ambient air temperature. What's interesting is the impact that is known already to have on the workplace. Increased heat exposure is shown to cause an increased risk of bodily harm, injury caused by fatigue and reduced vigilance. Well, the very essence of most workplace accidents happen because of reduced vigilance. Because somebody, even though they were trained, even though they were given instructions, what the courts have said, a momentary lapse of inattention, of attention, could sometimes lead to very serious accidents. The accident rate, the accident incident rate is minimal when your workplace is at 17 degrees to 23 degrees centigrade, but increases with lower or higher temperature. You can empirically show there are more accidents at those outside temperature ranges. And you know, there's a number of factors that can explain this, but even just physical dexterity can be impaired, as can cognitive performance. And so again, one of the studies says this can lead to negligence regarding safety procedures and reduce vigilance during the performance of dangerous tasks. Similarly with dehydration, which again can be quite common in a hot environment. You get reduced cognitive performance, reduced visual motor capacities, short-term memory, and again, the word vigilance. These are foreseeable events. And so the question is, well, what do you do as an employer about these things? On top of that, those studies are for the normal population. Add on top of that, there are some people who are even more vulnerable to the effects of high temperature. Over 45 years, people with known health problems, people who are overweight, sodium-restricted diets, pregnant women, workers required to wear PPE. We've all been through COVID. We all know how hard it is to work in a hot environment while you've got a mask on, let alone all the other PPE that some people have to work. So think about the intersectionality of all of this. Think about heat-stressed work environment with a 55-year-old worker who has health problems, is on a sodium-reduced diet, and is wearing PPE. And now go back to the list of likelihood of a workplace injury at the end of the day. You know, a clear and obvious connection there between a changing work environment because of climate change and an increased risk of workplace injuries. You know, some of the obvious ones are outdoor workers who would likely be impacted, but indoor work in a poorly air-conditioned environments. Those of you who may work in workplaces that, you know, in the middle of July aren't properly air-conditioned, understand what that could mean in the end. Any manufacturing facility, and again, any type of job that requires additional PPE in a hot environment is going to make it worse at the end of the day. And again, just a list of some other types of industries. So what would a due diligence response look like to heat risks? Well, first and foremost, evaluate your workforce for those risks. Keep in mind those temperature ranges, keep in mind the impacts, and keep in mind the tasks that you're asking the workers to do. Can you stay within that range? Consider the need for individual accommodation if your workers fall within those highly susceptible areas. Improving air quality is key, and it hits on some other areas as well, but it always comes down to improving air quality and improving air temperature. Keep up with the technologies. PPE does change, does improve over time. It gets lighter weight, it gets more breathable in some cases where that's possible. And look at the frequency of breaks. Again, you know, especially with cognitive tasks, breaks are really important and matter, especially in that. And so recognize the risks. You go into some industrial establishments nowadays, and there are charts with urine color codes, so that the person can see right away, are they dehydrated or not? You know, hugely important, especially with in some industrial jobs. And keep an eye on seasonal transition times. Again, the research shows that at the change of season, the impact of high temperature is going to be more than in the middle or at the end of the season, because the workers aren't used to it. So those transition times are high-risk times for workplace accidents. Going into some of these other categories now, over and above heat, is increased exposure to air pollution. It's one you maybe don't put a lot of thought into, but volatile chemicals, ranging from pollutants that are already in the air to things that are being used. If you're a facility that uses solvents, that uses cleaning fluids of any type, these generally always contain some volatile chemicals. Well, with a higher air temperature, they're going to become more volatile. There's going to be more of them in the air. If workers are sensitive to them, then that sensitivity is going to increase. If you're in an area, and most of us in Canada are, in areas that are susceptible to forest fires, then that's an impact on outdoor workers and potentially on indoor workers as well. An interesting one is the allergen season, the pollen season. In the Northern Hemisphere, the pollen season has increased by 15 days in the past 30 decades. What does that mean? If you have workers whose performance is impaired because of allergies, you've got 15 more days a year where that performance is now impaired that you had 30 years ago. And so think about the impact on your workforce of something like that. What do you do about air quality? Well, there are specific air quality regulations for some industries. Know them. Look at doing indoor air quality surveys. There are consultants that will do those for you. See what can be done to improve air quality. With ground source pollution, and that can be even natural sources like methane or radon, keeping the floor slabs, concrete floor slabs properly sealed is key. And again, a consultant, an indoor air quality consultant will help you with that. And for outdoor workers, if there's a need for PPE as well. Some more exotic things with climate change. There are more certain vector-borne diseases are more likely to happen, and we've all heard about West Nile virus in recent years, since overtaken by more pressing concerns like COVID. But they're still out there, and these type of diseases are becoming more common. So again, does this mean that your workforce may suddenly shrink because more workers are ill? Again, we've all been through this with COVID. We understand the impacts these things can have. There are simply more of them out there that are likely to be coming through. This is a potentially really big one for employers, and this is the increased frequency and severity of extreme weather events. Those of us from Ontario went through a pretty big storm in the spring this year, and storms, floods, water ingress into your buildings, tree damage, power outages, fires, these all put your workers at heightened risk while they're on the workplace. Obviously people like first responders, transportation workers, agricultural workers, tourism, but pretty much any workplace is going to have this. Think about your landscaping, even if you're just a normal office environment with some landscaping outside. Are there risks to workers if they're there during a storm? Again, with climate change, many of our traditional trees are more and more diseased. Are those trees now more susceptible to being impacted by storms? Could that put any of your workers at risk? What about the building envelope integrity? We're building our buildings for a certain level of storms. If those storms are increasing, are we more likely to get water ingress in areas that we didn't expect, and therefore get mold growing in areas we hadn't looked for mold before? Are you using portable trailers? A lot of school facilities do. How are these designed to handle more frequent storms, higher temperatures? Are they properly ventilated? Are they protected from floods and from mold damage? So contingency plans for the storm are crucially important as well. Think about what happens during a big storm. If you have shifts, you may not be able to do a shift change. You may have people staying longer than they needed to, which means they're going to be more fatigued. You may not be able to replace them. Do you need to shut down the operation? How do you keep it safe if that happens? If you have an unexpected power outage, I see this a lot with my industrial clients. Again, transition times are the dangerous times. Quick, sudden outage of power could cause equipment to stop. Power comes back. What if that equipment starts up again? And it's not properly guarded, not properly protected. So power outages are crucial, and all of those transitions times. An interesting one in one of the papers talked about workers being stressed just because of the fact that they are about to be hit by a storm and worried about their home and their families as well as their work. So these things all require a certain level of accommodation from you. Just quickly, ending on this one for you, think about the new technologies that climate change is bringing in. Larger capacity batteries, hydrogen fuel cells. These are all new technologies. They are being manufactured, which means that we have industrial facilities who are creating new chains of manufacturing that maybe haven't thought through the safety protocols yet because they're new. They're also being used in the workplace. Some of these could be considered hazardous materials if not handled properly. If they're coming in as new technologies, you won't have due diligence policies in place as to how to handle them. So think about those new technologies when they come in. Think about proper disposal. Think about the fact that your newer buildings are going to be better sealed, and what does that mean about indoor air quality? So all of this is saying, be aware of these things and think about them. Because again, that acting reasonably is going to take a lot of work, but just simply not being aware of what are obviously foreseeable risks right now is clearly not going to get you across the line in terms of that. So this is sort of the big takeaway for you, is just identify the new hazards as a result of climate change. Consider developing new training and awareness tools. Think about what changes might be made. Keep an eye on what others are doing, not just your next door neighbor, but within other jurisdictions. What's happening in Europe, what's happening in the US, what's happening in Asia, because we can all learn from each other. We're all tackling these same problems at the end of the day. And part of due diligence is keeping up with what the rest of your industry group is doing. Engage consultants, again, engineering consultants, and sometimes legal consultants. We actually do have something useful to say every now and then. But consultants are there, and part of due diligence is relying on expert advice. If it's not your field, then bring in an expert to help you, because ultimately you are responsible for your workers at the end of the day. And the key thing is, don't assume a previously safe workplace will continue to be safe, because your workplace was probably not designed to take into account climate change, and nor were your work processes. So I think we are reasonably in time, and I don't know if we have time for questions or not. I'll leave that up to Andre to figure out. Thank you.
Okay, thanks everybody. I think now is a scheduled break, but if anybody has questions, by all means, either ask them now or come up to us or find us during the day. And other than that, thank you for being here and your attention, and hope you enjoy the rest of the sessions today. Thanks.